was surprised that somebody would make these kind of accusations. So, but whatever.
So if you go after Mr. Hornsby, the fact that he works for DWP, that's not gonna matter, because if it's criminal, if you can prove that what he did is criminal.
Yeah, it is criminal. It's definitely criminal. Because I read it myself in the perjury, in the criminal perjury. What the law says, the criminal law says about perjury. But it's funny that just saying but in a civil case, in a void judgment situation, all that perjury shit is not, it becomes null and void. Everything is voided out. All the perjury is voided out. That's why I was thinking that she be, huh?
Did you look it up under Google Scholar?
Look on the what on the Google Scholar?
Okay, defamation of what did he do? Defamation of character?
No, just defamation. It's called libel. Libel.
Okay, did you go to Google Scholar and look it up?
I'm not looking up that right now. No, I'm talking to you.
No, I said you got to do your homework on this stuff if you're gonna follow it up. If you want to know about good case law, go to Google Scholar and type in defamation, and then see what case law come up.
Okay.
And then you can read those cases so you understand yours better.
Yeah, that's fine. I mean, yeah, I understand. There's nothing wrong with doing research, man. I read stuff. I don't mind looking at stuff. I look at the main thing. One of the main things I have to do is look up what is criminal, like you said, criminal. What the criminal law say about perjury, and see what the elements are, and then you can look at see what the elements are for defamation, right? And then you can go, because I want to show because I didn't argue. Oh, in fact, I did put defamation, man. You won't believe this. You remember the attorney, saying that I never made a raise about defamation, or it wasn't a cause of action. Remember that?
Okay.
The same email that I sent the attorney in the lower court in my fraud upon the court case, in my fraud upon the court claim that I filed, I clearly put in that email to the attorney saying that Hornsby defamed my character. That word defamation. See? Defame.
Oh, okay.
So if I put that in the email, right?
Yeah.
Then you can say that I raised it in court, right? I raised it up, right?
I don't know. I don't know about that. I think when you raise something in court, you raise it in front of a judge. I think that's the whole purpose of raising an issue. Is you raise it in the courtroom.
Well, but yeah, I got what you're saying. But
the only thing I could say, if you sent an attorney an email, the only thing I think you can prove there is that you put her on notice of certain facts, of certain issues.
Well, in my fraud upon the court, I put that email in my fraud upon the court claim against the attorney, bro. So all this was in my fraud upon the court. All right.
Okay.
So had the judge looked at the fraud upon the court, she would have discovered that the man defamed my character, right? See, she would. If the assumption is the fraud, the fraud upon the court, should have called the judge made the judge to look at the evidence, right?
Yeah, but we know the judge been ignoring the evidence from day one.
It's very true. So, but the fact is, I did put the judge on notice and the lawyer on notice. This is what I said, brother. I said, this is my email to the attorney on February 7th, 2017. after reviewing my court records yesterday, I discovered that you submitted false information of material facts in the court records, which is fraud upon the court. Based on the discovery, at least one of your witnesses, Gregory Hornsby Sr., committed perjury by misrepresenting facts and made defaming statements relating to this incident that he cannot prove. Mr. Hornsby stated in his declaration, the Skelly package and Mr. Hilton's suspension were based on the evidence presented to me at me and Mr. Hilton's violation of BWP rules. That's what I quoted. But in the back, continuing on, I said Mr. Hornsby referenced sexual innuendos as to Mr. Hilton's behavior towards the customer. Yet the customer never indicated any sexual misconduct on behalf of Mr. Hilton. So that's my point. I indicated that he defamed my character, and he made reference to sexual innuendos.
And you put all that in an email to the DWP attorney?
Yes.
I sound like you definitely put her on notice.
Yeah, and like I said, I went into the sexual stuff, man. I said, the lady, I said, yeah, the customer, I'm referring to Odelia. The customer never indicated any sexual misconduct on behalf of Mr. Hilton. I said, so those were facts and misrepresentations listed below. And so that's when I said, Mr. Hornsby did not witness the incident, yet he made numerous false statements and assertions about Mr. Hilton's behavior, which contradicted the customer's version. I said, Hornsby stated that Mr. Hilton violated DWP rules, yet DWP has yet to produce legitimate department violations of material facts. I said, Mr. Hornsby stated that he listened to the recorded conversation of the customer's complaint, a complaint call after this thorough review. He concluded that the customer was credible. And this was Hornsby said. He concluded that the customer was credible. However, DWP never conducted a fair and thorough investigation relating to the incident, according to the administrative manual. Hornsby indicated that the dog was a threat, but the customer indicated the dog was no threat. I gave all this to the attorney, man, before I filed fraud upon the court on it.
But Hornsby is not a fact witness because he has no personal knowledge. Am I correct?
Yeah, of course. He's not a fact witness, but the thing is that he
because if the customer says the dog was no threat and Mr. Hornsby was not at the scene when this went down, therefore he has no personal knowledge, how does he have the right to say the dog was a threat?
Because he's arrogant, and his motivation was to retaliate. His motivation was to retaliate to the thing to set me up for termination.
All because you made complaints to IFTA, the Equal Opportunity Commission.
Yeah, that was the basis of it. Yeah, because I complained to IFTA. Yes.
Yeah, sound like you got a good retaliation case.
You can see that this man Hornsby, when he went all the way around the block to get me, he didn't have nothing. They had to make it up. So my point was that for reading that to you is to show that I informed the attorney.
Well, it sounds like the court violated the Federal Rule 56C because these people have not produced any affidavit or declaration with that statement being sworn to.
See, you gotta understand. See, the reason why I couldn't argue my case in the lower court at the time, because it was all about me responding to the summary judgment. That was the whole thing. That was the whole conversation. It seemed like every time I went to court, which was only 3 times before the ruling, it was to deal with to respond to the summary judgment. So that was all the conversation about. It wasn't about, okay, let's argue about the witnesses. Let's argue about this these false statements that Hornsby made. It wasn't about, even though that was in my paperwork, but it wasn't, seemed like that wasn't part of the proceeding. Because it wasn't about that. It was about me giving me more time to do what? To respond to the summary judgment.
Yes, but in the summary judgment, a judge is not supposed to rule in the defendant's favor if they have not produced a scintilla of evidence. Now, from what I'm understanding is Federal Rule 56C says that they got to produce sworn affidavits by any fact witness that was there who said that you done these things. And according to what you telling me, there's nothing in the court records under an affidavit or declaration, Federal Rule 56C, stating in an affidavit that you done these things.
Well, true, but Hornsby made himself a fact witness, which made him out to be a perjurer. Okay, and that's the problem.
So and so right there, when for them to allow Hornsby to submit double hearsay, basically, because that's what it was. He said somebody else said something, so that's double hearsay, and his affidavit is no good if it's around double hearsay and he was not a fact witness. He that affidavit ain't any good.
The attorney is using Hornsby's. They're using Hornsby's unfounded statements to suspend me. They're using his disciplinary action and attach that to his affidavit. So they're killing two birds with one stone. They just attach his disciplinary action, all the false statements he made, and attach that to his declaration and made that his legal document as a fact witness of everything. That's what the attorney did.
Again, that falls up under abuse of discretion by the court. That's abuse of discretion because Federal Rule 56C tells you what the procedures are, what the guidelines and what a judge has to follow. And in your case, it sounds like the judge did not follow that procedure.
No, I understand that. I'm just showing you what the attorney did. I'm just articulating, the stuff that what the attorney allowed Hornsby to do. And so the judge, he just ran with everything and just let the attorney write up the ruling, and she just signed off on it.
You should be able to get that case reversed based on the fact that the judge abused her discretion and she allowed this declaration to come in, and the declaration was based on double hearsay by a non-fact witness because Hornsby was not there. He has no personal knowledge.
Yeah, she allowed double hearsay. In fact, and I put hearsay in my judicial notice. I told the judge that this was hearsay by Hornsby, by the managers, by DWP, and that woman, and she still ignored it. Put in my judicial notice. So yeah, we know the judge abused her discretion. There's no question about it.
There's also abuse of discretion in your case because you said you did a judicial notice.
I sure did. There's several of them.
Okay. Do you know the rule on Federal Rule 201, filing a requesting a judicial notice? Do you know the rule?
The judge is supposed to accept the information in that judicial notice if it's related to the case.
But it also tells you that a judge has to grant a judicial notice if a party requests it.
If a party requests it, yeah.
And the court is supplied with the information.
Yeah, I didn't know the exact verbiage, but yeah.
So you requested a judicial notice and she denied you, is that correct?
Mm-hmm.
So you can get your case reversed on abuse of discretion on that alone.
It was granted if a party requested, and if they're supplied with the necessary information. But it also says that if they're supplied with the necessary information, yeah, that's very true. And the judge ain't supposed to say, "Well, I didn't listen to it. I didn't listen to the tape." Wait a minute. I supplied you with the information. You're supposed to listen to it. Because see, had she admitted to listening to it, then she'd have been on the hook for then why you ruling against him then, if you listen to it. But see, had she listened to it, it would have been an explosion. Huh?
I hear you.
Yeah, it would have been an explosion. Because now the judge is on the hook now. Because then she would say, well, you listen to the tape, you admit to listen to the tape, but then you're gonna rule against him still? Yeah.